Good morning. Welcome to DMH Sallard's latest employment law webinar. And for the past few webinars, really, we've been talking about the new working world and been discussing how different organisations are planning to approach working in the future. Today, we're going to hone into a couple of areas in more detail. I'll be looking at some of the contractual issues that arise as a result of some of the changes that are likely to take place. And after that, my partner, Stephen Hove, is going to look at one complex problem, and that's employee monitoring. So before we start, a couple of pieces of housekeeping. You'll see at the bottom of your screen two buttons. There's the chat button. So if you've got any problem with connection, anything like that, you can't hear us, then just use that and we'll then try and rectify the problem for you. And then there's a Q&A button. If you've got a question about what we're talking about, then please do use that, pose your question, and I'm sure that we'll have time at the end of the session to go through some of the questions that you've got. Okay, I'm going to start off therefore looking at some of the contractual issues. And any change in work arrangements, if we move to the next slide, any change in work arrangements is likely to involve a change in contractual terms. And I'll be looking at four areas, and that'll be where you're changing the workplace, where you're changing the hours of work, changing somebody's duties, and then finally looking at the financial elements to or aspects to some of these changes. Let's start off by just reminding ourselves why the contract of employment is important. The contract is an agreement, so it may well limit your ability to implement change within your organisation. Probably over the last 18 months, if you reflect on things, the contract of employment has kind of fallen back in importance in some aspects, because people very quickly were willing to change their place of work, start working from home, changing their hours, sometimes changing their duties in response to what was an emergency situation. And very few people turned around and said, well, hang on, yeah, my contract of employment doesn't allow that. It doesn't stipulate that I can be required to work from home. Because everybody was cooperating in that emergency situation. But it's always been there in the background, and my view is that it's probably going to become increasingly important, and there'll be increasingly scope for argument in terms of contractual arrangements as new arrangements are made for returning to work and the new working environment. And the basic principle still exists, that an employer cannot unilaterally vary the terms of employment. So that means that the employee will either need to secure, the employee's agreement. And if it can't do that, then it's going to have to consider dismissal and re-engagement. And that may bring with it the need to collectively consult. So you've got the mechanics of changing the contract of employment that are always there in the background. The first area that I'm going to look at is changes in the workplace. And I'm going to be looking at the situation where, if we move to the next slide, looking at a situation where we're asking somebody to spend some time of their working week working from home, whether it's all from home or just part of it. And what are the contractual implications where the employer is wanting to do that? Well, the first thing that the employer needs to do is to look at the existing contractual arrangement and see what that says about where the employee works. And is there sufficient discretion reserved to the employee to vary the workplace? Now, most contracts of employment will either stipulate a single workplace, or they'll stipulate that an employee's place of work is X, but they may be required to work at other premises of the employer. Or sometimes it's a geographical mobility clause, so that you can be required to work anywhere in the southeast, for example. But does that, even if you've got that mobility within the place of work clause in the contract of employment, does that extend to being able to require an employee to work to yourselves certainly 2 years ago, well, you know, is there an implied right to require an employee to work from home, as opposed to providing them with an environment to work in, such as an office or a factory or a shop? Then people would say, no, you can't just require somebody to use some of their private home space to work from, to incur additional costs as a result. So even if there is some mobility built into the contractual term relating to the place of work, it's unlikely to permit the employer to demand that the employee works from home. Could the employer argue that the workplace has already changed as a result of working from home during the pandemic? I think that's very, very unlikely. So probably you'll be looking at how do you secure the employee's agreement to this contractual change. Well, the starting point is obviously discussion, and then I think you're looking at incentives, making sure that any additional costs that the employee is going to incur through working from home are met by the employer. But if that fails, then you may have to consider using the possibility that the existing role is redundant in order to secure the employee's agreement to a change. Remember, redundancy arises where an employer's requirements for employees to work in a particular location diminish. So if, for example, you're asking everybody to work from home, then you may be able to use redundancy as an argument to effectively force through that change. What about asking employees or allowing employees to work from abroad? I think that the short answer is don't do it if you possibly can. Don't allow it if you can possibly avoid it. Obviously, there's nowadays a lot more mobility amongst staff. We've shown and it's been proven that you can work remotely effectively. So increasingly, we're asked to advise employers about employees who want to work outside of the UK. The biggest risks arise in relation to tax, in relation to immigration, and in relation to employee rights. If you allow an employee to work from, say, France or from Spain, they may well have local employment rights, which may go further than UK employment rights. And if you want to look at that area in more detail, one of my partners, Adam Williams, has done a webinar on it, and that can be found on our website. Another area where I think that you'll need to look at some of your contractual provisions and rules is in relation to security of data if people are working from home. Are fresh rules necessary? Now, it may be that you have a very comprehensive set of policies that cover data security, but the things that you need to be thinking about are access to information and how it's stored. So if employees are working from home, how are they going to store confidential files? How are they going to transport confidential data to home? How do you make sure that things aren't left at the bus stop? What about what devices can be used? What protections are going to be attached to those devices? Who else has in the household has access to those devices? How will they be locked down and secured through passwords, etc.? So all those things are likely to be on your agenda if you're implementing this sort of change. And then the other area is probably reporting sickness. I mean, it's when you've got an employee working within the office or within a factory environment, it's self-evident that they'll need to report sickness. But what are the new rules going to be if they're working from home? Okay, so moving on, still looking at the question of workplace. What about if we are now asking people to attend at the workplace where they haven't been working at the workplace, where they've been working from home? What are the contractual issues? Well, again, the first thing to do is to look at the contract of employment. And it's probable that the contract of employment hasn't changed, so that you're in a good position to say to an employee, right, now's the time to return to the office or the shop or whatever. Can an employee argue that the workplace has now changed because they've been allowed to work from home during the pandemic? Again, it's very unlikely that an implied right to work from home has arisen over the last 18 months, so probably not. What other barriers might there be to requiring employees to now attend at the workplace? Well, we've talked in the past, other seminars, about health and safety issues, and Section 44 and Section 100 of the Employment Rights Act and the health and safety provisions, where an employee can refuse effectively to attend in the workplace where they have a reasonable fear of serious and imminent danger. Now, whether or not an employee can use that to refuse to return to the workplace has been a moving feast. It changes as the situation with COVID changes, and it probably has to be said that right now, with rates as they are, there's still a possibility that an employee could refuse to return to work on health and safety grounds. And even if an employee does return to the workplace, we've always got the possibility of flexible working requests. They may ask to work from home, they may ask to work from home on a full-time basis. And I've been asked to advise in relation to some pretty extraordinary requests made by people in jobs where you would think, no, there's no possibility of being able to work from home. But those requests are being made, and the employer has to consider them carefully. And that situation may well change in the employee's favour. The government is talking about a right to work flexibly. So keep a close eye on that as well. So if you're thinking about implementing change in terms of the workplace, what are some key principles that I would encourage you to keep in mind? Well, the first one is clarity. I mean, I think always there is clarity is helpful within the employment environment. Everybody knows where they stand. But there has to be, I think, a balance with flexibility to tailor personal circumstances. And I think that we have to recognise that COVID is a situation where there are very different personal circumstances, different personal attitudes. And so therefore we have to be ready to tailor any particular rules to an individual's personal circumstances. And that's most obvious where you've got employees who are vulnerable or perhaps disabled. Second key thing, I think, nobody knows what the future holds really. So I would encourage you to retain the ability as the employer to change or to vary the arrangements. And I would also encourage you to keep a focus on fairness, whether that's fairness as between different groups of employees or as between individuals within the same group. Moving on, let's look at changes in hours. What I want to do now is to just ask you to take part in a poll. Are you proposing to make any changes to working hours in the next 3 months? And whilst you do that, I'm going to close my back door to get rid of that noise. Right, well, we should see the results coming through in a tick. Right, so for lots of you're not making any plans to change working hours in the next 3 months, but roughly a quarter of you are. Okay, well, let's have a look at some of the issues that arise in relation to changing hours. Well, there's been quite a lot of talk in the HR press about a change in focus away from using hours as being the measure of an employee's output towards outcomes. So different sectors will have different approaches here, but certainly I think that we will see, where it's possible, a move towards focusing on outcomes rather than just individuals being at work for a particular number of hours. But even there, you've got a number of permutations. You could have set hours, you could have core hours within which people must be working, or you could have a situation where there'd be no set hours at all, as I say. Keep in mind the working time regulation implications. They apply to people who work from home as much as they apply to people who work within the workplace. There's a maximum 48-hour week. Have you arranged for employees to opt out? Is there a greater opportunity to invite people to opt out? Might you be able to argue that people who are working from home, who are in a management position, who effectively have control over their own hours? And I think the other area in relation to the working time regs is record keeping. There is an obligation to maintain adequate records to show that individuals aren't being asked to work excessive hours in breach of the regulations. What's your approach going to be to record keeping in relation to people who work from home? If you are planning to change people's hours, again, the first port of call is to look at the contract of employment and ask yourself, well, do we as the employer have a discretion to change hours? If you haven't, then it will be necessary to obtain the employee's agreement to a change in hours, or again, possibly to consider dismissal and re-engagement. It's possible also that any new arrangement in terms of hours will cover the old working arrangement, so it won't be necessary to change any of the rules. The new regime covers the existing situation. But again, in terms of key principles, I would stick to the ones that I mentioned before: clarity, balanced with flexibility to tailor to personal circumstances. Make sure you're in a position to change or vary the arrangement, and keep a focus on fairness. The third area is changes in duties, and what are the contractual issues here? There may well be a need to refine an individual's duties or the activities of an employee. It could be that those are relatively minor. It could be that they're well within the scope of the job description. So all we're really doing is just operating within the existing job description. Well, there's no problem there. What about if there's a more fundamental change to somebody's role as a result of the new working world? What are you going to need to do in relation to that? Well, first question again is to look at the contract of employment and ask, well, do we have a discretion to make the change in duties? Many contracts do say the employee may be required to carry out other duties as required. So explore whether you've got a free hand there. If you haven't, then you'll either need to obtain the employee's agreement or you'll have to think about dismissal and re-engagement. And again, how might you secure the employee's agreement? Well, if the changes are sufficient to be able to say that, well, really your old role no longer exists, then again, redundancy potentially comes into play. So you might be in a position to say to an employee, right, well, your existing role because of the changes is redundant, but we do have an alternative role to offer to you. Then the final area that I'm going to look at is just changes in some of the financial arrangements. We've had questions about London waiting. What do you do where you've got an employee who receives London waiting on the basis that their job is based in London, that they have to suffer the aggro of travelling into London, etc., but they are now working from home? Do they still enjoy the benefit of that London waiting? Can it be withdrawn by the employer? I think that the answer probably is, unless you've made it very explicit that London waiting is contingent on and conditional on the employee continuing to work out of the London base, it's very difficult to remove London waiting. Similarly, in relation to travel allowances, if somebody is in receipt of, for example, a car allowance or some other allowance, then yeah, you might be able to remove it if they're now working from home, but only if the contract is clear that the allowance is conditional on the employee continuing to work in the workplace. So tread carefully there. What about the additional costs of heating, electricity, broadband that will be incurred as a result of individuals working from home? Well, probably as part of getting the employee's agreement and cooperation with new arrangements, employers are going to have to consider making contributions to those areas. Certainly in relation to equipment being used at home, it's highly unlikely that an employee is going to be keen on fully equipping their own home as an office. So some level of contribution, cooperation, possibly funding all of it will be necessary there. Lastly, what about how we record these changes? Well, one obvious point is that it is important to make sure that we record these changes properly so as to avoid disputes in the future. Do you need to send out a new contract, or is a letter setting out the variation and the changes adequate? Well, it probably depends upon the extent of the change. It's significant change. I would suggest sending out a fresh contract. Section 1 of the Employment Rights Act requires you to keep the statement of the main terms up to date and record any changes. And then, just as a reminder, 3 key areas. Consider including trial periods. Include an option for both parties to review the situation if it's not working for either party, and include an option on the part of the employer to vary the arrangement. So I hope those are some useful pointers in relation to some of the contractual issues. Stephen's now going to look at a much more complex issue in some respects, and that's employee monitoring.
Thank you very much, Simon. Yes, now you've got your employees working at home on a flexible arrangement, coming into the office occasionally. Do you consider how to monitor them? My talk is going to explore the issue of monitoring your employees. It's a tricky one because it involves a number of different areas of law which intersect. And what I thought I would do is look at your obligations under the Data Protection Act 2018 and the GDPR. Use how you implement that act in your workplace, and then use that as an example of how the pathway that GDPR prescribes assists you in dealing with other forms of claims as well that may come out of monitoring. But I think the first question to ask is, why should you want to monitor your employees at all? And the obvious answer to that, I think, and particularly important with remote working, is monitoring the quality of their work and indeed the quantity of their work for performance management. Monitoring the time that they're in work when in the office and when working remotely. You may be required by regulation to monitor what your employees do, for example, their calls in financial services settings. We're all used to being told when we ring our bank or our insurance company that our phone calls may well be recorded. This form of recording is a regulatory monitoring requirement. Evidence collection for disciplinary and grievance procedures. We're all aware of this, but this is in fact a form of monitoring. Monitoring employee health in particular, particularly where you're concerned about the long-term health of somebody. And monitoring employee interactions with third parties, quite a tricky area, where you think that employees are leaking confidential information, or they may be in breach of their implied obligations of fidelity, or planning to be in breach of their restrictive covenants. You might, in those circumstances, want to monitor their emails. You might want to monitor their phone calls, at least insofar as their phone calls are made on devices that are supplied by you. So if we move on to the next slide. So there are several means of monitoring. In fact, the means are endless, but I thought I would just pick just a few to set the scene. The first is, of course, CCTV. I use CCTV as an initial example because it's so obvious and invasive, as a Conservative cabinet minister had recently discovered. But there are other less obvious ones. For example, desk monitors. I've got a client who has a small device that he can put on your desk at home, and it monitors whenever you leave your desk and whenever you return to your desk. And it knows when you sit down at your desk in the morning, when you leave your desk in the evening or for lunch. There are also location monitors, and I don't need to tell you that your phone, for example, monitors exactly where you are pretty much all the time if you have the relevant apps. There's no reason why a work supplied phone can't monitor your location and what you're doing very closely indeed. And what you can also do is employ algorithms and other mechanisms for scanning emails and the use of words and the pattern of emails, their flow within the business and the flow outside the business. Again, this is particularly useful where you think your employees are acting against your own best interests. So that gives you a bit of a, I hope, a brief introduction to the type of monitoring, although it's a very wide subject and I'm dealing with it in a very brief manner. But I thought I would ask what is quite a dangerous question for the purpose of my talk. Do you currently monitor your employees' activities in any way? Because I think if 100% you say no, then that may render the rest of my talk less interesting for you all. But I'd be interested in the result of this, so off you go. Oh, a substantial number. 18% don't know, which I'm not surprised about. I assume the figure might be a little bit higher, but quite a number of you do already monitor your employees' activities, 31%, and 51% do not. Thanks. Moving on, I thought I'd add an additional question in. Do you intend to revise your monitoring procedures to take into account those employees who now work part-time or full-time from home? Well, 10% of you do, 55% of you don't, and a third of you don't know. So I don't want to persuade anyone into monitoring, but at least the rest of my talk will be of interest to half of you and maybe of real benefit to the other half. So if we could move on, please. What is the relevant legislation? Some of the relevant legislation is, I think, pretty obvious, but other bits are not. The most obvious piece of legislation is the General Data Protection Regulation of 2018, implemented into UK law by the Data Protection Act 2018. There's now a UK GDPR Act, which essentially preserves the GDPR into UK law by a complicated mechanism. And so it's pretty much as it was, which is to be expected, because as long as you have data flows between the UK and the European Union, those data flows are going to have to be governed by broadly the same legislation in order for the UK to have an adequacy which is necessary to receive EU data. A couple of rather more obscure acts. The Investigatory Powers Act 2016 largely deals with the way that governments and quasi-governmental bodies can intercept communications. But there is a section of it which deals with the ability of businesses to intercept telecommunications, and that is developed in the Investigatory Powers Interception by Business, etc. for Monitoring and Record-Keeping Purposes Regulations 2018, which I won't dwell on any further, but it's there to be looked at if you wish to intercept telecommunications as a business. You will have to do it in accordance with the 2016 Act and the 2018 regulations. Over the page, please. Some are less obvious. The European Convention on Human Rights and the Human Rights Act 1998 are relevant. Article 8 of the Human Rights Act gives you the right to privacy and to a family life. The right is not absolute, but if you're being spied on by your employer, you're arguably in breach of that Article 8 right. It's of particular relevance, of course, to the public sector and those in the public sector or quasi-public sector who have direct rights under the Act. But all your activities will be viewed by the courts on the basis that they will have to comply with the Human Rights Act where possible. Next is the Employment Rights Act 1996. If you invade your employees' privacy, you breach their human rights. If you breach your obligations to them under GDPR, if you're eavesdropping on them when they haven't given you their permission, you might also be constructively dismissing them under the Employment Rights Act, and everything that flows from that flows from your acts. So they may be constructively dismissed, you may be in breach of your implied obligation of trust and confidence, and indeed you may be in breach of some of your express terms of your contract of employment. And then finally, there's the Equality Act. I hope that none of you are foolish enough to monitor people on the basis of a protected characteristic, but some forms of monitoring can potentially discriminate indirectly against some people as opposed to others. And if that is the case, then they will have the right to bring a claim under the Equality Act as well. And many of the cases in this area involve a number of strands of the relevant legislation that I've just mentioned. So moving on, where can you find some guidance for this which will help you doing what is right and in the correct way? The first port of call, and I think the most useful area, is the Information Commissioner's Office Employment Practices Code. It's almost 100 pages long, but it's actually quite a good read. What you need to do, though, is take it with a small pinch of salt, because I'm afraid it predates GDPR, and it predates the Data Protection Act 2018. So it's been supplemented by the Employment Practices Code supplementary guidance by the Information Commissioner's Office. But the difficulty with the supplementary guidance is that it doesn't have the status of a code. So if you're implementing the Employment Practices Code at the first bullet point, you have the benefit of that as you would with an ACAS code. But the supplementary guidance, which takes into account GDPR and the Data Protection Act 2018, is only guidance. It's not a code, so it doesn't protect you in the same way. At a European level, there is an Article 29 working party, which has since in the last year or two become the European Data Protection Board. And they provide opinions and guidelines as to the operation of GDPR in the European Union. And although we don't have to take cognizance of what they say any longer, it is nonetheless very useful to have that sort of high-level guidance from the European Union as to how they see GDPR operating. As always, if you're in breach of any of the practice codes and guidance, it may be a factor in deciding if you're in breach of the law, but you're not in breach of the law if you breach the practice codes. As with the ACAS codes, it's something which is taken into account, and there's no markup as there is with in damages as there is with an ACAS code. So they're really much for guidance. So moving on, please. So it all looks pretty difficult. It's like a jigsaw puzzle that kind of meshes together. And much depends on the approach you take to the individual circumstances that you have in mind. But I think, as I said at the beginning of my talk, that the broad principles of what you should do are pretty similar. So what I'm going to do is to show you broadly what the GDPR code says and how that's applied to monitoring in the workplace. And then I'll show how it's also relevant, the same pathway is relevant to other areas, other acts. Next slide, please. So how do you comply with the GDPR when monitoring? Well, the first thing you need is you need to have a legal basis for processing any data at all, including monitoring. And usually that is the consent of the employees or the legitimate interest of the employers. There are other legal bases that you can use, but these are the most frequently used. The difficulty with consent, however, is that you firstly have to obtain consent, and consent of the data subject, your employee, can be withdrawn at any time. And just when you might be getting interested in what they are doing or not doing, you'll find that they withdraw their consent to you allowing to monitor what they're doing or not doing. So the best way of establishing it is establishing a legitimate interest of the employee in the data processing, the monitoring that you intend to do. So how do you do that? You must process data in a fair way. You must process it transparently so people know what is being processed and what you intend to do with it. You need to limit processing to what is necessary, and you need to limit processing to what is proportionate. I always think proportionate is the modern word for reasonable. Moving on. So, according to the guidance, you must identify the interest detect when you commence monitoring. By proportionate, ensure that the monitoring does what it's supposed to do and no more. The monitoring that will be lawful will obviously vary from company to company. This is something which is emphasized in the guidance. So each employer must establish its own interest in monitoring and dealing with its own issues. There's no way that you can use a template from somebody else and apply it to your own business. Remember that information collected covertly can only be used in limited circumstances. If you decide that you wish to film tills where you think you're suffering losses, you can only use the data that you've got for that purpose alone. You can't then export it to use it for something else. And also covert collection of data requires a very limited number of people to be in on the collection. You have to be very careful about how you do it. And be cautious when using artificial intelligence and algorithms due to the unfairness and risk of discrimination. A lawyer in this area was having a chat to me the other day, and he said that of course algorithms are prejudiced because algorithms are created by people. So the mere fact that you're using an algorithm doesn't mean that it is in some way more neutral than you are. So take great care when using algorithms. So moving on. So a few practical steps. Carry out an assessment of your company's need for monitoring and what type of monitoring is required. And of course, this will vary from company to company. A very important one, and something that comes out in the case law, as we'll see, is there any way to achieve what you need to achieve without monitoring? If so, it's much simpler not to monitor. Consult your employees or their representatives on what you intend to do. And this, I think, applies to covert monitoring as well. You can set out the circumstances broadly where you would want to covertly monitor. Produce a written policy. The written policy should make it clear the extent of the monitoring, its purpose, how it will be carried out, and how the information will be used. And then you have something which is agreed with your employees as being sensible and proportionate. The second thing is keep your privacy notice up to date. Many of you will have created one just before the GDPR came into effect. If you have a number of staff now working from home and you need to change the way you monitor them, ensure that your privacy notice is brought up to date to take that into account. Ensure as few people as possible do the monitoring, and this is particularly important with covert monitoring, as I said, and have access to the data. There's an emphasis on the seniority of people when it comes to covert monitoring. It's seen as being necessary only for very broad reasons, and I usually suggest to clients that they restrict the access to the data to the head of HR and members of the company board. Retain data for no longer than is necessary. This is a core obligation under the GDPR, but it's a sensible one. And it means that it doesn't come out in 10 years' time that you've been monitoring someone's health. And review any monitoring that you do periodically, so that if, again, going back to virtually this first point, if you no longer need to monitor people, don't monitor them. Review it consistently, I would say about once a year. Moving on, please. If you do those things, then that will create a framework in which you can operate your obligations under GDPR. But it seems to me that if you go through the practical steps above, they also assist with other potential claims. We could begin with constructive and unfair dismissal under the Employment Rights Act, for example, for breach of implied duty of trust and confidence. you can explain to the tribunal the reasonable and in some cases the contractual and legal basis on which you acted when dealing with the particular piece of monitoring that you've been carrying out. And that will, in some circumstances, give you a defence to any claim under the Employment Rights Act, which will be, but at least the tribunal will be sympathetic to you because you have been shown to have thought about the issues that are raised by implementing monitoring. Claims of indirect discrimination. The same process, I think, goes a long way to establishing a proportionate means of achieving a legitimate end. You've established your legitimate end, you've established what is proportionate, and I think it's not bulletproof, but at least it's a good start to coming to defending a claim of indirect discrimination. Moving on. Likewise, broadly, the same rules apply with the Human Rights Act, 1998, and a breach of Rule 8. You can show that a potential breach of the Act is legitimate and proportionate, which is the test, which is the broad test that is used by courts in claims under the Human Rights Act. And finally, of course, the big one, it'll enable you to defend claims or referrals, put it more correctly, to the Information Commissioner's Office, which are can be very, very substantial, with up to fines of up to 4% of global turnover, or £17.5 million. Again, you show how you got consent, you show a legitimate interest, and you show that you implemented the monitoring in a proportionate way. And so I think that it would greatly assist you if you were in dealing with the referral to the Information Commissioner's Office. And in fact, you might be able to prevent one altogether because someone would make a complaint to you. Then you can set out the basis on which the monitoring had taken place. So I think that can be very useful. Lessons from the case law. There are a number of cases now on these various issues. So I wasn't going to spend any time going through individual cases, but broadly they go as follows. The key questions seem to be, does the employee have a reasonable expectation of privacy in GDPR cases? Has the employer a clear and transparent policy setting out why monitoring is necessary and how it will take place? Is the monitoring necessary and proportionate? Again, you've thought about this, so it's in your policy. Is there any less intrusive way of monitoring? This comes up again and again, not only in cases of GDPR, but also in the human rights cases, which are linked to monitoring as well. This is a question that the courts ask themselves again and again. Is there any less intrusive way of monitoring? If there is, use that instead. And that's all I have to say on that. I concede a very brief, very rapid walkthrough, but I hope it's of use and gives you some form of structure for this really difficult area of employee monitoring. Simon.
Okay, well, thanks, Stephen. That's been really interesting in a complex area. We've got a little bit of time left, and we've received some questions. So let's see if we can answer some of those for you. The first question is, it relates to people who have moved out of London towards the regions. And the question is, we have a number of individuals who've moved out of London to pursue a better lifestyle or bigger property, etc. This results in a much longer commute for them if they were to attend the London office every day. How can it be fair to allow them to not have to do the long commute, but to require others who are more local to do the commute? It creates a disparity. Any suggestions on how we manage it? Yeah, it's a tricky one, and I think that it's probably quite a common problem that people over the last 18 months have decided to move out of or away from, perhaps the crowded southeast to more rural pastures. And what if the employer is now saying, well, you need to come in and attend at work? I think that if you say to employees who have chosen to move a long way away from their workplace without really thinking about, well, what are the implications of that move if if things return to normal and we're required to attend at the office. If you just allow them not to attend at the office, it does create a huge sense of unfairness. Those who have remained living close to the workplace, they're required to come into the workplace. They may not want to. And so you've created a significant unfairness. My view is that probably there's scope for compromise here. Is it possible to say to everybody, right, well, you've got a choice about where you work, you can work from home, but there are certain key meetings, for example, that you have to attend at the office, or there might be a minimum level of attendance that is required. So you can find a way of accommodating both those who have chosen to move further away, but at the same time not creating an unfairness on those who have decided to stay close to the workplace, because it does seem to me pretty unfair to demand that some employees attend at work whilst allowing others to work from home. Another interesting question: how does mental health stack up as a reason to not come into the office? So if employees say that they suffer anxiety about coming into the office given their fear of COVID or commuting, would we need to allow them their request, i.e. to continue to work from home and avoid coming into the workplace? Well, that is a difficult one. I said in my presentation that we have to think about tailoring to particular circumstances. And the most obvious one is where people do have some condition which makes it difficult for them to attend at work. Now, technically, one of the issues that arises here is if somebody is saying, well, look, I'm anxious about traveling on the underground, on Southern Rail, whatever, does that anxiety amount to a disability? So do we have to bring into our thoughts reasonable adjustments? Do we have to make sure that we've got justification if we do decide that we're going to require them to attend at work? Anxiety on its own probably isn't a disability. Typical cases on mental health focus on, okay, what is the impact of the condition rather than what is the technical diagnosis of the condition. But certainly, if that were my workplace, I'd be thinking very hard. Okay, well, do we have a disability here that we need to deal with? But even if you don't have a disability issue, so that the individual employee isn't able to say that they're disabled, so they can't demand that you make reasonable adjustments or adapt the policy for them. I would encourage you to tailor to particular circumstances. We don't know how long we're going to be living in this sort of world. It may change for the better, we just don't know. But for now, I would tend to err on the side of accommodation to try and support your staff in relation to those sorts of difficulties.
Yeah, I think it's particularly difficult if you get into a major spat with your employee and they end up being dismissed or resigning. As Simon mentioned, applications to the tribunal under Section 100 of the Employment Rights Act, and the case law there has sort of gone both ways, hasn't it, Simon? With some tribunals being sympathetic towards the employers and more or less dismissing the employees' concern about the imminent danger to their health, and other tribunals have taken it very seriously indeed. And there have been some surprising decisions where employers have succeeded on a Section 100 application, which have caused me a bit of surprise. And so it really is a very fast-moving and pretty tricky area, I think.
Yeah. Okay. Well, that's helpful. So I think we're both agreed there that exercise significant caution and look to be supportive of an employee in that situation. Then another question: if implementing an informal, flexible, hybrid working, whereby the employer is happy for employees to work from home or the office, depending on their preference, but they are required to come into the office for particular meetings, should a change be made to the contract or should just a policy be put in place as a framework? My view is that where you've got rules which are important to you, you need to be able to say, first of all, that that rule is clear, so that everybody knows what the rule is about having to come in for particular meetings. And you need to be in a position to take action if individuals don't comply with that requirement. So I think that you do need to be pushing it certainly into the level of a contractual requirement or a clear, reasonable instruction on the part of the employer that the employer expects the employee to comply with. I think the risk of just putting it to a policy is that a policy, unless it's expressed to be contractual or unless the requirements of the policy are expressed to be rules, there is a risk that a policy can be regarded as, if you like, well, this is our preference as to how things should happen, or this is our general approach to how things happen. And I don't think that would help the employer if you were in a situation where you were wanting to require the employee to attend at the meeting. So I would either stipulate it in the contract, or if it's going to go into policy, make sure that it's crystal clear that that is a rule that you expect people to comply with.
I would agree with Simon again here. I think it's an interesting use of words because the question says we have an informal, flexible hybrid working, whereby we're happy for employees to work from home. But I think that much of what is said to be flexible isn't in fact flexible at all. It's a new way of working, and you need to nail down the new way of working. If you truly want it to be flexible, then by all means be flexible. But I think in most cases, if employers properly analyze what they want, they don't really want flexibility. They want the ability to ensure that they have communication with their workforce and meetings with them when they want them. They don't mind employees working elsewhere at other times, particularly at home. But flexible is, in my view, a slightly confusing word. It means different things to different people, and lawyers don't really like that. We like our words to mean what we mean them to mean. And so you say, oh, we'd like an informal, flexible working arrangement, but many employers who say that to me don't actually mean that at all. They want something, as Simon has just described, which sets a framework, a legally enforceable framework for the way you're going to work together in the future.
Right, okay. And then I think our final question, which has literally just come in, so I haven't really had time to work out the answer. I hope Stephen has. If an employee has put in a flexible working request to work from home permanently due to their ethnicity creating a higher risk in relation to COVID, but the role requires some office work due to team development and knowledge sharing, what is the risk of discrimination should it be rejected and a hybrid working pattern adopted instead? Right, Stephen, I'll give you first go at this one.
Oh, cheers, Simon. Thank you very much. Well, the trouble with having a flexible working request is that whenever you turn it down, you have the danger of having a discrimination claim being brought against you. And like all flexible working, I would look into the claims with great care and to see whether there's anything behind the claim. What is the person's ethnicity? Why do they think they're at higher risk? And you can do this while consulting with them over their flexible work request. If the role requires some office work and there's nothing you can do about that, and again, you might want to think about that carefully, then it seems to me that you have to reject the request, and then you have what I think is an indirect claim of discrimination, and the way you defend that is by showing that you have you've gone through it very carefully in a consultation with the employee. You've set out why you need them to work part-time in the office. You've set out why it's impossible for you to make any adjustment, and hope that's good enough in a tribunal claim. And that's the way I would immediately look at it. And if it's all possible to accommodate the person, then you should do so. But I'd be interested on the basis on which the claim that the ethnicity makes you a higher risk for COVID is based. And I think the consultation draws out a lot of interesting things which might assist you deal with the problem. Simon, have you got anything to add to that?
No, I think there's close parallels here to somebody who wants to work, puts in a flexible working request, and who does it for reasons which are based on childcare. So they want to work part-time, or they want to choose their hours. Must you agree to that request? And the short answer is, well, no, under the flexible working regulations, no, there's no requirement to agree to it. But as Stephen says, you're always at risk of an indirect discrimination claim, and in that situation it would be an indirect sex discrimination claim. So if you've got a female employee asking to work part-time, you've got to be in a position to justify why you're saying no. I think Stephen's right that, well, the proposition in relation to the higher level of risk and the reasons that the individual employer is asking for the change need to be explored in detail. And Stephen, I would absolutely endorse what Stephen says about being very, very clear as to the reasons why it is not possible, why it won't work, because that's your justification defence in the long run in an employment tribunal. Okay, right. Well, those are all the questions that we have. I hope that you found the session interesting. We'll wrap up now, but thanks for tuning in, and we look forward to seeing you in the future. Thanks very much.